Hello, everyone. Welcome back to another episode. Let's jump into chapter 13. So, I got a quick question. If I promise to give you $100 for nothing, is that a contract? Nope. So, and if you don't understand consideration, you're losing easy points on an easy question. So, in the next 5 minutes, I'm breaking down everything you need to know about consideration. What is consideration? Well, consideration is pretty simple. It's the value exchanged in a contract. For a contract to be legally binding, you need two things: legally sufficient value and bargain for exchange. So, what counts as value? Well, a promise to do something you're not legally required to do, actually doing something voluntarily, or forbearance, which means giving up a legal right. So, an example could be I won't sue you if you pay me $100. That's a valid consideration. And here's the key: both sides must give something to get something. No exchange equals no contract. So, when is consideration lacking? Well, there are three major situations where consideration does not exist. One of these is pre-existing duty. If you're already legally required to do something, it's not consideration. So, an example of this, a contractor can't demand more money halfway through just to finish the job. An exception would be unforeseen difficulties or canceling and creating a new contract. Number two, we have past consideration. If something already happened in the past, it doesn't count. So, for example, I'll pay you for helping me last week. That's not enforceable. Why? Because no bargaining happened. So, number three is illusory promises. This is when a promise isn't actually a promise. So, for example, I'll buy your car if I feel like it. That doesn't bind you, so there's no contract. Next, let's go into settling claims. There are three main ways legally where disputes get settled. One is accord and satisfaction. Accord means agreement to accept something different, and satisfaction is completing that agreement. So this works best for uncertain debts. Number two, we have release. One party gives up the right to sue. This must be done in good faith, usually written, and supported by consideration. Number three, we have covenant not to sue. This means basically an agreement to not file a lawsuit. What's the difference? Well, it doesn't always eliminate the original claim. Okay, let's go into exceptions. Sometimes a contract is enforced even without consideration. So, in the case of promissory estoppel, for example, if someone relies on a promise and gets harmed, the court may enforce it. And also, in the case of promise to pay time barred debt. So, even if it's too late to sue, a new promise makes it enforceable again. Next, we have charitable subscriptions. These are promises to donate, and they can be enforced, especially if someone relied on it. And then we have promissory estoppel. How do you actually prove it? Well, I'll tell you. To prove promissory estoppel, you need 5 things: clear promise, expected reliance, actual reliance, harm, and enforcement needed to avoid injustice. So, quick recap: consideration is value and exchange. No consideration, well, that's pre existing, past, or illusory. Settlements: The three ways are by accord, release, covenant. And then exceptions, we have this promissory estoppel, time bar, debt, and charity. I hope you learned something today, and if this helped, tag along for the next video.